Good afternoon, everyone, and thank you for making yourself available for today's special meeting of the Fort Ord Reuse Authority Board of Directors for Friday, September 28, 2018. Pledge of Allegiance, if Colonel Ford would lead us, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Very good. Acknowledgements, announcements, and correspondence. Mr. Hulemark.
Yes, Chair, members of the board, just a few announcements today. First, I think at all of your tables you have a copy of the brochure of the annual report. Last 2 months ago, everyone received a copy of the full and complete annual report. It's also available on our website, and I know all of you have read that with great interest, and I know it put you to sleep every night you did. Number two, the Honor Our Fallen Run is going to be coming up on Saturday, October 20th. That's a 5 and 10K run. The revenues that are raised from that are generally produce lots of support for our veterans in the region. On Tuesday, October 23rd, is the ACE Tour. That's the America's Competitive Exchange. That ACE Tour is something that this region has hosted in the past. This particular year, our colleagues in the Department of Commerce asked Josh Metz and the FORA team to work with the Central Coast Marketing Team and the cities of Marina, Seaside, Monterey, and others to provide a tour of the region and the opportunities associated with that. This will bring together about 50 senior level business, government, and others. I know our good colleagues at the Defense Language Institute Naval Postgraduate School will be participating. I understand, Colonel Ford, you'll be TDY at the time, so might not be able to participate. But that ACE Tour is going to be on October 23rd. I know many of the folks in this room will be participating. And then Saturday, October 27th is another support effort for our regional veterans. And as all of you are maybe aware, Robert Norris, who is our resident staff person who handles our Veterans Affairs, is one of the leading folks that gets involved in this Heroes Open. He's trying to hide in the back of the room today, but he will be participating in the annual Heroes Open on October 27th. Usually about 100 golfers in this region all show up at Black Horse and Bayonet right here on the former Fort Ord to help raise funds for homeless vets and others. Most of the funds from this wind up contributing to the next phase of the Central Coast of California Veteran Cemetery. And then finally, there is a great opportunity for all of you to volunteer. I think the mayor of the city of Marina can tell you a lot about how this works, but this is the Fort Ord National Public Lands Day, which will be October 27th, where there's a great volunteer effort that's available that helps to keep the Fort Ord National Monument both clean and appreciated. Chair, that's all I have. If the board members want any more information on these items, it'll all be available at www.fora.org.
Thank you, Mr. Hulemark. If Authority Council would read us into closed session, please.
Yes, thank you, Chair, members of the board and public. Item 4A, closed session, conference with legal counsel, Government Code Section 54956.9A D1, Keep Fort Ord Wild versus Fort Ord Reuse Authority, Monterey County Superior Court Case Number 17 CV 4540. That's pending litigation. 4B, conference with legal counsel, Government Code Section 54956.9A D1, Marina Community Partners, LLC versus Fort Ord Reuse Authority, Monterey County Superior Court Case Number 18CV871, also pending litigation. And finally, 4C, conference with legal counsel, potential litigation, Government Code Section 54956.9 D4.
Okay, is there any public comment on any of these items? Seeing none, we'll go into closed session. Okay, if Authority Council would read us out of closed session, please.
Thank you, Chair, members of the board and public. The board met in closed session and heard from legal counsel on item 4A, which is Keep Fort Ord Wild versus Fort Ord Reuse Authority, Monterey County Superior Court case number 17CV4540, pending litigation. There's nothing to report out after hearing from counsel on that. Item 4B, conference with legal counsel, Marina Community Partners versus Fort Ord Reuse Authority, Monterey County Superior Court case number 18CV871, pending litigation. The board heard from counsel, got recommendations, and there is nothing to report out there. Item 4C, conference with legal counsel, potential litigation, Government Code Section 54956.9D4. The board heard from counsel there and was advised on certain matters, and there's nothing to report there.
Very good.
Thank you.
Thank you so much. All right, the next item is roll call.
Supervisor Parker? Here. Supervisor Phillips? Here. Supervisor Adams? Here. Mayor Edelin? Here. Councilmember O'Connell? Here. Councilmember Morton? Here. Councilmember Hoffa? Here. Mayor Rubio?
Here.
Councilmember Alexander? Here. Mayor Carbone? Here. Mayor Gunter? Councilmember Garfield? Kathleen Lee? Toby Uptain Villa? Erica Parker? Mike Zeller? Dr. Diffenbaugh? Dr. Blumenthal? Dr. Ochoa?
Here.
Is that Hunter? Okay. Thank you. Colonel Ford? Here. Bill Collins? Here. Dr. Triblee? Lisa Reinheimer? Here. And Dr. Moore?
Here. Very good.
Oh, I'm sorry. Councilmember Reimers? Here. Thank you. You have a quorum.
And let the record reflect that Mayor Gunther is here. Okay, very good. Oh, okay, we're starting off already. All right, let's go with the consent agenda, which consists of approved August 10, 2018 meeting minutes, the Administrative Committee, Legislative Committee, Executive Officers Report, Economic Development Report, and public correspondence to the board. Is there anybody on the dais that would like to pull anything for further consideration?
So I just would like to have some clarification on E. Just a couple questions.
Well, we'll go ahead and pull it.
Thank you.
Anybody in the public like to pull anything for further consideration? Is there any public comment on the consent agenda? Seeing none, I'll entertain a motion for the remainder. To the motion and a second. All those in favor?
Aye.
Opposed? Motion carries. Item E. What was the clarification, please?
So on item E, this is the Economic Development Report. At the last page above the signature lines is where we have identified how many housing starts we had in each fiscal year. And so when we look at the total there, in 17-18, it was projected we'd had 258 housing starts. My question is, don't we have an accurate number? Yes. And what is the accurate number? Because when I am adding those housing starts, the CFD generated through 17-18 would be 20,665,000. So I'm trying to see if there's a change in that number too. Thank you.
To bring you an updated number.
Okay, so you'll bring that next meeting?
Yes.
Okay, thank you very much for your assistance, Josh.
Sure.
Any other questions on this item? Any questions from the public? Okay, seeing none, I'll entertain a motion. Okay, is there a second?
Wouldn't we rather bring it back with the corrected numbers as compared to approving it now?
We can,
I should have said we're receiving this report,
right,
but again, so my motion,
sure.
because the motion is to receive this report with direction that it'll come back next month.
Second.
Stating the CIP.
Very good.
Second.
Okay, there's a motion and a second. Is there any other discussion? All those in favor? Aye. Opposed? Motion carries unanimously. Thank you. The next item is a business item. The number one, item C, item A, is consistency determination, City of Seaside zoning code, second vote.
Yes, Chair, members of the board, this is a second vote. Jonathan Garcia will have a brief comment. I think the board received a letter from Keep Fort Ord Wild, I believe at 10:55 today by email. There are copies that are, if anybody interested, Jonathan will address the item.
Yes, since the vote was not unanimous at the last meeting, this returns for a second vote. The only correspondence received since the last meeting was the correspondence at your table that Executive Officer Humar just mentioned. City of Seaside, Kurt Overmeyer would like to say a brief statement, and then we'll turn over for questions.
Thank you, Chair and members of the board. I apologize, but I made a mistake in my statement at the previous hearing. We set aside the 35 acres around the nurses' barracks via city council resolution rather than what I said, which I thought it was in the settlement agreement. It was not in the settlement agreement. It was just passed by resolution by city council, and I apologize for any confusion that caused.
Okay. Are there any questions? We already had a full-body discussion on this at the last meeting. Is there any other? Yes.
I'd just like to comment that, I was one of the no votes last time on this consistency determination, and I just want to say, as I believe I said then, I really like and approve of Seaside's senior housing project, but whether we like the project or not is not what's before us. It's consistency, and the increased density is not consistent with the base reuse plan. So that's why I'm voting no. Also, the community park, since that was agreed to by the City of Seaside, I'm puzzled as to why that wasn't formally adopted and amended into in this document. Right, the thing that we're being asked to say is consistent. So those are my concerns, and they haven't changed since the last time. So thank you.
Ms. Reimers.
Well, I'm not an attorney, but I'm confused about this a little bit, and possibly I'm the only one. The consistency factor for the Seaside is based on, as I understand it, that it's inconsistent with the base reuse plan. There's another project having to do with Corridor Road that I understand is being challenged because it was in the base reuse original plan, and now it's considered as outdated. It seems to me we're getting two sets of moral guidelines here. One way we look at the plan and we think it's all right, and it matches the base reuse, but it doesn't because you don't want it to because it's outdated. And another, it doesn't because it's updated because we need to have the space and the density. And am I the only one who is seeing an inconsistency in the reaction to these plans? And that doesn't need to be answered. It's just a question I have.
Okay. I'm going to go ahead and, is there any comment from the public? Seeing none, I'll bring it back. This is the second vote. I'll entertain a motion.
Move approval of staff recommendation again.
There's a motion and a second. Let's have a roll call vote, please.
Director Rubio?
Yes.
Director Parker? No. Director Adams?
Yes.
Director Phillips?
Yes.
Director O'Connell?
Yes.
Director Hoffa?
Yes.
Director Alexander?
Yes.
Director Gunter?
Yes.
Director Reimers?
Yes.
Director Edelin?
Yes.
Director Morton? Director Carbone? Director Garfield?
Yes.
It's 11-2 vote.
Thank you. So that passes. All right, thank you very much. The next item is the building removal program, second vote. Mr. Brinkman.
So this item also was not unanimous at the last meeting. The motion that was voted on was to seek every effort to obtain a response from the Department of Finance as to the feasibility of bonding the FORA property tax and to authorize the executive officer to solicit and execute service contracts for financial advisor and bond counsel to explore the feasibility of bonding FORA property tax to complete remaining base-wide building removal not to exceed $75,000. So that's the motion from the last meeting did not have unanimous support, but it was a majority, so it returns to the board for second vote. And staff's available for any questions.
Okay, again, there was pretty robust discussion on this item at that meeting. Yes, ma'am.
I just have a clarification question on the actual wording of the recommendation. The recommendation says take a second vote to complete remaining base-wide building removal. It doesn't say to seek counsel to help figure out how to fund that. And so I'm sure it's just wordsmithing, but I think that we ought to be voting on a resolution that has the appropriate wording in it.
So we'd be voting on a resolution that was attached at the last meeting.
It was not a resolution, but it was a motion, and the motion is captured in the background discussion.
Okay,
of the
can
staff
you,
report.
for the benefit of the board, repeat that?
Sure. The board voted on a motion to seek every effort to obtain a response from the Department of Finance as to the feasibility of bonding for a property tax and to authorize the executive officer to solicit and execute service contracts for a financial advisor and bond counsel to explore the feasibility of bonding for a property tax to complete remaining base-wide building removal not to exceed $75,000.
Okay. Mr. Hoffman.
So would the bond be extending beyond June of 2020? Or what is the likelihood of us being able to get a bond to meet these obligations that would be retired before June of 2020?
So what we know today is the revenue source is there today of approximately $3 million a year is what FORA is collecting on property taxes on the base. So that would be the revenue source that we would seek to bond. So that's the feasibility of figuring out after 2020, is that a resource that can be bonded upon. So that's the reason staff has come to the board to seek authorization to look into this feasibility.
Mr. Chair?
Thank you. As you know, my concern last time was committing to spending $75,000 without checking with the Department of Finance first to find out if this scheme would even fly. And I appreciate Councilmember Garfield including checking in with the Department of Finance as part of her motion. What update do we have on progress as far as checking in with them?
In terms of
the Department of Finance, have we, what progress has been made in?
We have not contacted the Department of Finance on this question. It's the intent of staff, if authorized to move ahead with the feasibility, to have the appropriate team investigate that issue before going into a full feasibility study. We want professionals to make sure that's clear. Based on at least the discussions I've had with our staff, it's currently a revenue source that FORA has the authority to bond against. The state law makes that clear. What we brought up at the last meeting and expressed concern about was that when redevelopment was downsized in the past, a year before that occurred, there was a stop any further commitment from the Department of Finance. So I want to make sure that before we go through a whole feasibility study, get professionals to make sure that we have an opinion that says we can do that. So I think that's the appropriate way to go. If you go to Department of Finance and say we're going to obligate something way into the future, I think I know the answer you're going to get immediately. Would be difficult, but it would require an Attorney General's opinion, probably longer than we have. So my thought was, since this did not succeed, that we would make that part of any study and be the first thing up.
Right. Thank you.
Yes, ma'am.
So then the motion that's being made is to commit up to $75,000 for council, bond council, financing council, to evaluate first if it's feasible. Then feasible vis-a-vis an opinion through the Attorney General or State Department of Finance first? Or are you asking them strictly to look at the Authority Act and then the feasibility based on what our current tax revenues are? Trying to understand, because I heard two different things.
Okay. My apologies if I wasn't clear. I believe that the reason why we would hire a professional to look at this is to determine what our authority was, what we believe it is already, and to determine if there is anything that would prevent us from bonding against future revenues. And that would be the first thing we would do before we would look at the feasibility of how much, how many years, how much would be obligated. I think that would be my proposal to move forward with this. I don't know that the Department of Finance is going to give us an opinion. They're not going to do that themselves. They're going to seek opinions from the Attorney General's office, and it takes quite a bit of time to get an Attorney General's opinion. So it's not rational to do it that way. I think we should simply get professional support as to whether or not we have the authority to proceed.
And then the second being in that 75,000 is the financial feasibility. Am I understanding it correctly? But
The rest of it is the financial. It's both the authority, the revenues, and what the feasibility is to get the sufficient funding that we need to complete the building removal program.
Okay, then I did have another question on the staff report at where your potential financing plan, it says for our land sale proceeds in fiscal year 1920 is 21.2 million. I wanted to know which parcels we're identifying that would be sold.
Yeah, that includes property in City of Delray Oaks, City of Monterey, and City of Seaside.
And are they currently under DDA agreements? How are we relying on that source of 21.2 million?
So in terms of each of those jurisdictions, City of Delray Oaks has an option agreement for the sale of that, for a land sale to occur in that year. City of Seaside is currently in exclusive negotiating agreements with developers. And then City of Monterey, I don't believe they have a developer at this time.
So if those revenue sources do not come forward, how does this get funded?
So without those revenue sources, then, well, you would need the money in the bank to do the building removal, so it would just delay it until there is land sales or another resource identified to finish the program.
Thank you.
Yeah, I would have expected that some of the questions we're asking to have answered would in fact be what we're getting consulting for, to say if these are too speculative, or what would the financial markets do in response to this scenario and situation, which we don't have that expertise here. So I'm hoping that what I'm hearing is that we will get people with bonding expertise to tell us whether this scenario actually could fly in bonding markets. And is that what you're expecting? That's
Yes.
the expertise you're hoping to hire?
Yes.
Okay, thank you.
If I supported this last meeting, I supported this meeting to get information. However, it's not a done deal by any stretch of the imagination. If we are in Delray Oaks right now, it wants to use the money that we have for our land sales and for a CFD for the good of the community. If we have a FORA that goes on, FORA itself or FORA Light, and we're all together in one group, that's fine. If we start splintering, and certain cities do not want to be part of this organization, Del Rio's money is not going to go to any organization that's not part of FORA or part of a regional cooperative approach. So again, I think getting information, trying to figure out what we're doing, that's fine, but we are not going to pledge all of our land sale revenues or any CFD to any other organization outside the FORA itself. The other thing to remember here is this building removal was never part of the initial base reuse plan itself. This is an addition of the 20 million plus we have for the habitat conservation plan to ensure we're plussing up the CalPERS liability so none of the non-land use jurisdictions get stuck with something if FORA goes away, and plus the other mitigation efforts we have to do. We still have a lot of money we have to raise just to meet the base reuse plan. This right here is outside of the original base reuse plan. It's nice to have, I'd like to do it, but it has to be part of a comprehensive program where everybody's together, everybody's working together. If we splinter, this will not fly whatsoever.
Okay, I'll go ahead and open up to the public comment. Seeing none, I'll entertain the motion. Motion and second to approve the motion as was stated. Roll call vote, please.
Director Rubio,
Yes.
Director Parker,
I'm a little more comfortable with checking to make sure that there's nothing that would stop us from exploring these things, so I will vote yes.
Director Adams,
I voted no last time, but I'm changing my vote to yes.
Director Phillips,
Yes.
Director O'Connell,
Yes.
Director Hoffa,
Yes.
Director Alexander,
Yes.
Director Gunter,
Yes.
Director Reimers,
Yes.
Director Edelin,
Yes.
Director Morton,
Yes.
Director Carbone, Director Garfield.
Yes.
The
Very
vote
good.
is unanimous.
Unanimous. Thank you.
Do the happy dance.
While we're on a roll, huh? That's very good. Okay, the next item is the University of California, Monterey Bay Education, Science, and Technology Center update.
Yes, Chair Rubio and members of the board, this is a presentation that originally was scheduled in October, and it was then moved to September, and then moved to September 28th. And our colleague, Chancellor Blumenthal, has adjusted his schedule so that he could join us this afternoon. The University of California has been involved in the Fort Ord Recovery Program since the very beginning, and in fact, representatives from the University of California, Santa Cruz actively engaged at the task force work prior to the closure in an attempt to try to stave that off. Their involvement has been continuous ever since then. It includes the work of Dr. Gage Dayton, who works at the UC Fort Ord National Reserve, doing great work here. Chancellor Blumenthal, for the last decade or more, has provided the leadership from the campus. In that regard, the Chancellor has worked feverishly to try to do everything they can to be a part of this overall program in the region. And today we'll hear from him in a moment, but Josh Metz, who was just minorly called on the carpet for a minor item in the previous economic development program, is going to make
No, I appreciate that. I'm actually...
Before you start, Josh, I'd like to welcome Chancellor Blumenthal again to the FORA board and to thank him for his service over the years to the wider regional community as Chancellor at Santa Cruz, University of Santa Cruz, and congratulate you on your retirement, upcoming retirement.
Well, thank you, Chair and members of the board, and indeed, Chancellor. Chair, you sort of stole a little bit of one of my punchlines, which was to remark about the Chancellor's own transition plan that he had just announced. But it is indeed an honor to be back up here just for a short moment. And Member Morton, thank you for reading the Economic Development Report so closely. I was really here to just encourage everybody to read the report because we got a lot of exciting things going on there. While I do need to update that number, there is information in the report about our continuing efforts in what we're calling now the DART initiative, which is drones, automation, robotics technology, and we see that as an organizing principle for economic development in the region. We have some really exciting things happening there, including recent connection with the folks who developed the country's first drone business park at Grand Sky, North Dakota. So there'll be more information about that forthcoming in the weeks and months ahead. Lots of exciting activity at the Marina Airport, and also our continuing partner with CSUMB partnership, where we're working hard to bring together the second Monterey Bay Sustainable Hospitality Summit, January 10th and 11th here in Monterey. So lots of exciting things happening. As I've said before, this is a great time to be in economic development. Might not have said that 10 years ago or 8 years ago, but lots going on here. It is indeed an honor to serve. And before passing the podium to Chancellor Blumenthal, I would, just from a note, from an academic standpoint, I've been reading this book lately called The New Localism. It's put out by the Brookings Institute. Bruce Katz is one of the lead authors. And it touches on topics that are pretty much couldn't have been better written for the type of work that we're all doing here. So if anyone's looking for a good evening read, I would encourage you to do that. Without further delay, UCSC Chancellor George Blumenthal.
Well, thank you so much, and thank you for the warm welcome here. It really is a pleasure to be here. You know, yes, I am retiring next June. I guess I couldn't stand the thought of being chancellor if there was a danger that FORA would dissolve. So I couldn't imagine a world without FORA. Anyway, I want to just give you an update on some of the things that are happening with regard to the UCMBEST property in Fort Ord. First of all, cooperation with our partners is really key, and we're working hard to advance our region's and the university's mutual goals. We continue to work closely with our partners at FORA, the County of Monterey, the City of Marina, as well as others on the prospective commercial tenants and buyers, particularly in the vicinity of the Marina Airport. Like many of you, we are very encouraged by the City of Marina's successful negotiation with Joby Aviation, which was referred to earlier, to establish a new headquarters for that startup company at the Marina Airport. And we believe that this does create opportunity for other related industries to locate at the airport, and that will be a great benefit to this entire region as well as to the university. So I think that portends an exciting future. Another exciting research opportunity, after a year of discussion, autonomous vehicle research at MBEST, roadway system on the Central North Campus, will be starting up quite soon. We're extremely pleased to announce that the Ford Motor Company will be using the existing street system to test their autonomous vehicles on our Central North Campus property. This one-year lease was finalized the first week of September and also includes a lease of an office suite and a minimum of 5 days of use of MBEST Drive and Research Drive. To conduct this research, the County and City of Marina have agreed to close MBEST Drive, Research Drive, and University Drive during these periods of use. We think this is extremely encouraging. As a way, this may open up doors to offer the companies with similar interests to eventually join in this effort, an effort that really is bringing a new high technology business to this area. We are also very encouraged about the potential for high-tech drone technology research at the Marina Airport. I think that's really important. As many of you know, the Federal Aviation Administration put forward a process to designate or select a number of airports throughout the country for drone research. This past spring, the university was a co-applicant with the City of Marina and with FORA to establish drone research and development designation at the Marina Airport. We were encouraged by the prospect of this type of research, and several members of our faculty were also quite supportive and active in this. However, the application that we put in was unsuccessful, at least initially, and we will continue to request a designation in the future for FAA competition, in future FAA competitions, to engage our faculty in this effort where appropriate. I see this as a major area where our faculty can really be involved in activities in this region. So along with the presence of Joby Aviation, I think the potential in this area of research is very intriguing and offers us some real promise for future collaborations. In other news, I'm pleased to report the pending sale of the West Campus. As some of you may recall, as part of our 2011 visioning plan and process, and several of you were involved in that, as well as the subsequent MOU, we agreed to proceed with the sale of the West Campus as a means of spurring along economic development. As part of the plan, we agreed to reduce the UC footprint and concentrate on planning and development of the Central North Campus. In July of this year, the university received a fair market offer of $4.2 million through a public bid process for the 49-acre West Campus, which is immediately across from MBEST, or at least from the MBEST headquarters, I should say, on Imgen Road. The potential buyer, Rutherford Investments, has many Silicon Valley connections, as well as several property holdings already in Marina. And while Rutherford has not come forward yet with specific plans, our preliminary conversations do indicate that they want to develop the space to complement the nearby airport development, to complement the commercial space that's by providing commercial space for lease, for restaurants, and for hotels. And I think this represents really a terrific opportunity for more job generation and economic development in this area. I think that portends something good. Now let me turn to the Marina Airport and the MBEST specific plan. Now I will admit to you I have not been thrilled at the pace at which that process has moved forward over the last couple of years. But hot off the press, I am encouraged by a report I received from my staff that in a recent meeting we had with the City of Marina, we now appear to be on a path forward to complete the specific plan and environmental analysis within a year, within the next year. We will stay engaged and continue to work with stakeholders in the process to get over that goal line. We really do want to get that done. Now to the East Campus, otherwise known as the Blanco Triangle. The East Campus is the parcel located in the northeast quadrant of the Blanco Road Reservation Road intersection in unincorporated Monterey County. As an interim use, farming is being considered via a lease with the university. The lease will go out to bid, and we anticipate this happening this fall. With regard to the Habitat Conservation Plan, our work with the Fort Ord, and we've been working with the Fort Ord Natural Reserve as well, and we continue to support FORA in this area. As you know, that plan is moving forward, the HCP, and we look forward to the finalization, hopefully soon, of the HCP. But that is currently out of our hands and out of the hands of FORA. In addition, we continue to do community programming activities in FONER, or the Fort Ord National Reserve. We monitor rare, threatened, and endangered flora and fauna. We do work supporting research that helps inform management and stewardship activities. We provide research opportunities for surrounding partners like CSUMB and Hartnell College. And we provide financial support for a few local area schools to come and learn about the natural vegetation and habitat conservation efforts. As you can see, there is a lot happening on the UC property right now, which I think makes all of us feel as though we are in a good place moving forward. I'll talk louder so you can hear me. You have our commitment that we will continue to work together with our regional partners on our shared stated goals based upon the 2011 visioning process that we all went through. Like you, we want to see these properties used, and we want them to see them used not just to further UC educational and research mission, but also to being an economic driver in the region. That's the goal, and that's what we want to pursue. So I want to thank you again for this opportunity to be here. I want to mention that I'd be happy to take questions. We have several UC staff here who can answer more detailed questions as well. So let me open it up at this point.
Chancellor Blumenthal, thank you for that presentation. I just wanted to hone in on the last part where you talked about exploring the possibility of selling some of the property for agriculture. And I'm aware of researchers who are doing ag research at UC Santa Cruz, and would encourage you, as you explore that, to see if there's a possibility of some kind of an MOU that would permit your researchers to do some of their some of their research with whomever you sell that to.
Yeah, thank you. That's actually a very good point. As many of you may know, or some of you may know, we have a farm, a significant farm on the UC Santa Cruz campus, in which we do not just research on new farming technology, particularly organic farming technology, that has actually been of great benefit to many of the farms in this local area. But in addition, we do training internationally of people wanting to learn about farming, and we have trained literally hundreds of people across the world in how to do agroecology and organic farming. So I think you make a really good point that since we have such an active enterprise, it would serve us well to be in collaboration with whomever is occupying that property. So I take that as a very positive suggestion. Thank you.
Any other questions?
Please.
Very good. Ms. Garfield.
Thank you, Chancellor Blumenthal. It's wonderful to see a lot of efforts, maybe getting some traction and getting some energy, and getting to lift the whole project. So, I do have a question. Is that we have 12 federal entities here that are a really big economic driver, and many of them, and I think of Naval Postgraduate School, generate an enormous amount of intellectual property. And I'm wondering if that's something that InBest would be well suited to partner with the federal agencies here to look for commercialization opportunities in that way. Is that on your horizon?
Right. I think that's a really good point. And in fact, this is something we have been trying to do over the years, particularly with Naval Postgraduate School. We've had over the years, a number of collaborations with the Naval Postgraduate School, which involve the generation of intellectual property. So it really depends upon the nature of the research that's available, and the whether or not collaborations can be built between folks down here in these various 12, you said 12 federal agencies, I didn't know it was that many, and the faculty that we have at UC Santa Cruz. So, we have certain areas of strength, biomolecular engineering, we have some strength in autonomous vehicles, we have strength in, various other forms of, particularly computer engineering and storage systems. So that we have certain areas of strength, and to the extent that those areas of strength represent areas where intellectual property can be developed in collaboration with folks down here, I think that would be a great thing. So I'm totally supportive. And if there's ways that we can, synergize that and make that happen, I will certainly be anxious to do so.
It sounds like you've planted some good seeds. Thank you.
Any other questions? Anything from the public? Well, thank you, Chancellor, for coming personally and letting us know what's going on at UCSC.
Thank you.
Thank you. Yes, sir.
I was made a promise to George I would make this disclaimer. I am a former employee of the University of California at Santa Cruz. It is true that immediately prior to my work as executive officer, I had been an assistant vice chancellor at the university, and George did not fire me.
You left before you got a chance. Okay, the next item on the agenda is item 8D, Regional Urban Water Augmentation. Mr. Peter Said.
Thank you, Chancellor. Thank you, Board. Hopefully this will be a short one. Excuse me. As many of you know, this Board approved a $6 million reimbursement agreement with Marina Coast Water District in 2017 for the purpose of funding a shared recycled water pipeline as part of our capital improvement water augmentation program. That pipeline, which is being built by Marina Coast Water District, is to transport recycled water produced by the Monterey One Water Pure Water Monterey project. And because of this, the two agencies work together to gain grants and funding for the project from the state and other resources, one of those resources being FORA. In 2017, the state, which is providing a bulk of the funding in the order of $26 million, changed the way they would fund the project. This change required existing agreements between Marina Coast Water District and Monterey One Water to be adjusted to accommodate the new financing structure. As part of that, and as I explained in my report, this required MCWD and Monterey One to renegotiate a number of terms between the two agencies. And the one that pertains to this board today has to do with the funding that FORA provides for the water augmentation contribution. Staff got together, the executive officers and general managers of the agencies got together in November, December. They negotiated a solution, and then a solution was negotiated between the Monterey One Water and MCWD boards, and that was that MCWD would not object to Monterey One Water working out an agreement with FORA, whereby FORA used its water augmentation funds to decrease the cost of the finished water to be provided by both of the agencies. Therefore, staff has taken the time and we've worked out a very simple reimbursement agreement with Monterey One Water. The terms of the agreement are very straightforward, and that is that they invoice us and we provide them with reimbursement for the costs spent on two specific things: the Black Horse Reservoir, which is the new 1 million gallon reservoir that's currently being built, and the new shared pipeline. Each agency has a share in paying for the cost of both of those facilities, and so we're suggesting, and we have provided that for you in a contract, that we reimburse for those two items. This reimbursement agreement was provided by our staff, FORA staff, to the Monterey One Water staff for their consideration. They presented that to the Monterey One Water Board, who approved of that particular agreement. In looking at our CIP, we have sufficient funds budgeted for the 2018-2019 year to be able to provide for this water augmentation agreement. And because of these things, staff is recommending the board authorize the executive officer to execute a reimbursement agreement not to exceed $2.3 million in the fiscal year of 2018-19 for Monterey One Water's share of the new pipeline facilities. That agreement is included in your packet, and I'm available for any questions.
Any questions for Mr. Said? Ms. Morton?
So I tried to get my questions answered from Keith Vandermotten. I don't know if he was here, as to whether MCWD was in agreement with this payment. And the question that I have is, you said that the water is going into the Black Horse Reservoir, and is that reservoir provide water to the lands within the territory of the former Fort Ord?
That reservoir is a holding tank of 1 million gallons, and it's used for multiple purposes, not just to provide water. It currently sits east of General Jim Moore, east of the Black Horse golf courses, so it's in the Fort Ord lands. And part of what it does is provide pressure sufficient to provide the fire lines throughout the Fort Ord area.
So it is it will be serving the former Fort Ord.
That's correct. It does serve all of Fort Ord.
And what was the second place this water was?
It has to do, the money will be applied towards the pipeline that's being built between the facilities out at Marina Coast Water District and Monterey One Water, all the way through to Seaside.
So the difficulty that I'm having, and I'm trying to understand, is pure water. The Pure One project does not create any water for the former Fort Ord. And I understand the pipeline is being shared by MCWD, which the Marina Coast Water District has a right to portions of our CFD. But I'm trying to understand why Pure Water Monterey would have a legal right to our Community Facilities District funds. I'm trying to understand that.
So maybe Mr. Moore might have some a more detailed answer to that question.
I'll let.
Thank you very much. Sure, a couple of comments. First of all, the conveyance facilities are very nearly finished. The tank itself is being painted as we speak, and the disinfection process for the pipeline and the tank will be starting soon. Monterey One Water is paying for a significant portion of the conveyance pipeline and a portion of that tank It will serve both RUAP, which is a Ord community project, and the Pure Water Monterey project. The plant north of here, where Monterey One Water has its main treatment plant, they're building a Pure Water Monterey manufacturing facility, but it will be producing both water for the 3,500 acre feet going to the Monterey Peninsula Water Management District and ultimately to Cal-Am, but it will also be producing the water necessary for RUAP and the Ord community. So it is very much a shared operation, a shared pipeline. This payment was certainly a compromise. I think Marina Coast would have preferred to get all the money itself, but the changes that were referred to and how the state was putting conditions on the two loans, because Monterey One Water got a 1% loan, Marina Coast got a 1.8% loan. Don't ask me to understand the difference there, I don't. But nonetheless, that's reality. So this was a compromise position. As to the question about CFD funds to be used for part of this, I think that's a FORA board policy call, to be honest. But Marina Coast did agree to this.
And to answer the question about the legal right, so the FORA CFD does not have restrictions on, it can only go to certain agencies. So the CFD is collected. It's not limited to just MCWD for water augmentation per se, but Monterey One Water is eligible as well, as long as we can show that this project, which Director Warren just said, the two entities working together provide for this project.
Any other questions? Any questions from the public? I'll entertain a motion.
Move approval.
A motion and a second. Mayor Gunther and then Mr. Hoffa. Did you have a question? Okay.
I just wanted to comment that this is an example of FORA working with our partners on a regional project that benefits everyone. It's going to lead to less expensive water for the region. It's going to lead to more sustainable water supply, and we should be very pleased with this outcome. This is a successful example of regional cooperation.
Okay, if there's no other comments, all those in favor? I did. Opposed? Motion carries unanimously. Thank you. Next item is the transition planning process update. Mr. Hulenward.
Yes, Chair, members of the board, Sherry Damon will line, as I noticed over there, she's sitting down. I hope that doesn't mean the length of her PowerPoint presentation. But we do have a PowerPoint presentation. There's been a great deal of activity since the last board meeting, and I think Sherry will go over all the details here. Clearly, there's been a lot of press interest in this. We've made presentations before various cities, counties had a couple of conversations, at least 2 county Fort Ord committee meetings and 2 Board of Supervisors meetings, so there's been quite a lot of activity. I know members of the board all received copies of the City of Marina's resolution. In fact, I noticed the city manager was passing an extra copy out to everybody today, so you can read that one twice. So we have a number of items at your dais. I do want to just note that we've been getting a number of inquiries from individual community organizations, neighborhood associations, including the association at East Garrison, the associations that are newly formed here on Fort Ord have asked a number of questions about what was the original intent of the legislation to create FORA. Why isn't it a permanent program? Why did it have to go this long is a different question. We've had inquiries from state legislative staff on the program. We've had inquiries from state departments. All of those things have been surfacing over the last several weeks, including one from federal agencies that are doing research on the former Fort Ord and who want to know who is their contact for former Fort Ord recovery program. So given all of that, our answers to all of that can be found on the website. We've also formed a website for folks to contribute and make comments. And Sherry will go through all of that in this PowerPoint presentation, and then I'd like to make a few comments when she's done.
Thank you, Executive Officer, members of the FORA Board, and members of the public. My name is Sherry Damon. I'm the Prevailing Wage / Risk Coordinator, Risk Manager for FORA, and I've been tasked to try to work through the transition plan and the transition plan issues. So I am sitting down. That could mean it's a lengthy presentation, or it could mean I just have people in between me and anybody who wants to charge on provisions of the transition plan. But let's go through this. Oh, got to push the right button. So you've seen this before, just kind of the historical, what it looked like back when it closed and how it's starting to transition now. And I think Mr. Hulamard, our executive officer, referenced why FORA was established in the first place, and that it was a regional plan. It was a regional base reuse plan. The region acted together to come to some kind of consensus over what would happen with the plan and how that would be implemented. And FORA took many actions to implement that, from public financing to the base reuse plan to the community facilities district, and we've all heard parts of that. Whoops, let me turn the thing. So today I'd like to talk about where we've been. You've heard about a little bit about where we've been, what's new, the revised draft transition plan resolution that's in the packet, and some of the outstanding and key issues. So where have we been? Well, in 2017, this board, just to remind everybody where this board was in 2017, less than a year ago, this board said, let's transition by using a single entity. We want to complete the plan, and we think a single entity is the best way to do that. Make it a JPA, if that's what we need to do. We'd like to continue the CFD, so seek extension of the financing district, because that's essential to finishing the program. But if that doesn't work, use the implementation agreement, the percentage assignments for a jurisdiction's fair and equitable share, and the JPA would have been assigned the implementation agreements. So in implementing that, we have quite a lengthy history. As you can see, this board and its subcommittees and FORA staff have been working quite diligently to compile all the agreements that have been compiled over 30 years, the federal agreements, the state agreements, the interagency agreements. And every month we have been bringing that back to the FORA board, ultimately culminating in June 5th with a compilation, a complete compilation, a presentation to this board and the public of what we called at that time a draft plan. It was really a draft collection of agreements and policy decisions as we move forward. In July, we had additional board workshops, and in August, finally, in response to conversations with LAFCO and others, we came back with a draft transition plan resolution. LAFCO directed us to be shorter than the June 5th document. They wanted something short and more concise. So that's what we put out in August. Since that time, FORA staff and others, the jurisdictions, have had multiple meetings to consider the issue, and we find ourselves here today with a revised draft transition plan, and we've been doing additional meetings. All of those meetings in that background can be found on the FORA webpage in the current report, board report for this month on transition planning. There is a link. It takes you to a table in the transition plan webpage, and that table compiles all the jurisdictions' board reports, staff information, and background studies. So that was all on your calendars at that time. So we've met with and we've attended meetings at Monterey County, City of Seaside, City of Monterey, City of Marina. We've attended LAFCO meetings, and we've met with staff of LAFCO and Delray Oaks, Marina Coast Water District, and TAMSI. So what is it that we have to do? And this relates to one of those fundamental issues, and also directs us and directs this board what its duty is. And 67700 of the Government Code, or the FORA Act, says the FORA Board shall approve and submit a transition plan, and the transition plan shall assign assets and liabilities, designate responsible successor agencies, and provide a schedule of remaining obligations. The plan shall be approved only by a majority vote. And that's a question that has come up about, is it a one vote or is it two votes? And we can talk about that later. I think the language is fairly clear. The legislative intent here was it was a single majority vote. And I think there are multiple lawyers who agree with that, but everything else at FORA and the FORA Act says all actions of the board are approved by two votes. So that is one of the issues that we can talk about. So what's LAFCO's role? Well, LAFCO is supposed to provide the orderly dissolution, ensuring all contracts and agreements, pledges, and the authority is appropriately dissolved and transferred. There's a dispute between, or I think an issue in terms of what this language means. And that's what is sometimes called, and it's referenced in my board report, as the LAFCO FORA jurisdictional issue. Who has the ability to assign? What does this language mean? Does the Cortese-Knox-Hertzberg Act, which is what LAFCO usually acts under, apply to this situation? And it's FORA and FORA's counsel's position that it does, and that this plan, by adopting this plan, the legislature directed us to make the assignments. And that makes a certain amount of sense given the overall legislative intent of the FORA Act. The FORA Act, remember, was a regional body, a regional decision, and it would strike me that this language is a regional plan. But that's an issue that most likely will need to be aired out either by agreement, legislation, or litigation. So how does what you have before you comply with that direction? Well, we're directed to assign assets and liabilities. Sections 2 and 3 of your transition plan resolution address those things. We're supposed to designate successor agencies. That's also in sections 2 and 3. And a schedule of remaining obligations. Well, that's found in sections 1, 2, and 3. And there is now incorporated into the resolution the concept of transition plan implementation agreements. So the idea being that the FORA board approves a transition plan, and the underlying jurisdictions and member jurisdictions implement that plan through agreements. This allows an opportunity to meet what LAFCO has said that they want, which is they believe the only way to implement a transition plan is through agreement. This gives a discrete period of time to negotiate those agreements and bring those agreements back to the FORA board to look at and consider from a regional perspective that those agreements meet with and fulfill a transition plan. So more fully going through the transition plan resolution, this is how it's built. The first part of that resolution is the background and the factual background about how we got to where we are today and why and how we are adopting this transition plan. Section 1 defines what the board is assigning. What is it as a region we think need to be finished and completed? That is the purpose of Section 1. Section 2 defines who and how assignments happen. And if there happen to be omissions, and I hope there are not, but you know, there are a lot of agreements out there, and I was just reminded that MST has a line in our capital improvement program, but they haven't been called out specifically as one of our transportation obligations. So that's going to get fixed before I think this board takes action. But if there was something like that that didn't make it into the plan, there's a process for how you deal with those, if it's a real property obligation or an administrative obligation. Section 3 outlines the intent, the financial contribution targets, and allows for a schedule to be more fully implemented by transition plan implementation agreement. And so if a jurisdiction doesn't believe they will be able to build a road or address some issue in a capital improvement program, the transition implementation agreement, plan implementation agreement, is the place where that kind of flexibility can be built into the overall transition plan. Section 4 is CEQA compliance. It's a finding about whether or not this plan requires any additional CEQA review. And Section 5 is LAFCO review. What we request and how we request LAFCO to enforce provisions of the transition plan in the absence of agreements. So Section 1 basically has 6 elements. It defines this, it directs that the CIP defines the scope of projects, and so MST's project is within our CIP. It is directed to be addressed. It also makes a finding that the Community Facilities District is the best vehicle to ensure long-term revenue generation to complete the capital improvement program. It allows the existing implementation agreements, or actually it has a finding that they require continued funding and participation. Those implementation agreements were the underlying jurisdictions' collaboration and regional cooperation to implement the base reuse plan, and we are continuing that until the program is finished. That is the FORA position, and that's what's in the transition plan resolution. The Section 1 also talks about CIP projects or obligations to be assigned. It has it starts to outline and define what a transition plan implementation agreement is, and it talks about encouraging jurisdictions with future development have a huge opportunity, and I outlined this to the board when I gave my presentation. I know it was only 6 weeks ago, but in August, that Seaside, for example, doesn't have already entitled projects. For those jurisdictions that don't have already entitled project, it is easier to put replacement financing districts or community facilities districts in play. And Section 1 includes an encouragement to those jurisdictions to get going on establishing the replacement funding mechanisms. And it directs that in the absence of a fully executed transition plan implementation agreement, that all revenues that are generated from the implementation agreement formulas be put into an escrow account. So a single account to be put toward retiring the obligations under the CIP. So Section 2, this is where you have your assignment of your assets, your liability, and your obligations. It defines that we have 2 basic types of liabilities and obligations. They're administrative and they're real property based. We've talked about the administrative liabilities, mainly CalPERS, but also the indemnification agreement with LAFCO is in that administrative category right now. In general, administrative liabilities and obligations are assigned based on the FORA board voting percentage. That is what has been presented to this board multiple times. Those administrative liabilities right now are projected to be fully funded. To the extent that we can fully fund CalPERS, we have a Section 115 trust, and there are additional funds that we've got set aside for that. Additionally, we also have budgeted for at least 1 year of indemnification costs for the LAFCO indemnification agreement. And we try to deal with that by saying if we don't use it in one area, we're going to make that into another litigation fund or some fund to address future or ongoing litigation. We have real property related assets, liabilities, and obligations are generally assigned to the underlying jurisdiction unless there are agreements changing that allocation. So right now we've heard lots of talk about agreements from certain jurisdictions, and we would be most interested in seeing those agreements and if they can be brought back to this board in accordance with our December 2018 timeline. And this plan resolution allows for that. Additionally, Section 2 has the assignment of the contractual obligations in the table of assignments. The idea being that everything would be rolled in and addressed in a transition plan implementation agreement. Assets would be transferred as described, and after discovered items assigned as described in the process. Section 3, this is a meaty section, it has 3 slides. Lots of information here, but these are your bigger picture items, and they would more specifically be addressed in transition plan implementation agreements. You have habitat. The Section 3 includes a finding that habitat obligations, whether it's HCP or otherwise, would best be funded by the Community Facilities District, continuing the Community Facilities District, including capturing all of the revenue on entitled development, would be most helpful to funding habitat, among other things. The obligations would be passed to a joint powers agency if that is formed. If that is not formed, then the obligations would be passed to the underlying obligations, which they are already included in your deeds through the habitat management plan. And the funds that FORA has on hand would fund either an escrow or a trust to be directed for long-term habitat management. That could be habitat management areas and take permits. So you might recall, some of you I think attended the meeting on the habitat conservation plan that FORA held on Monday, and there was talk about the comparison between the HCP, which is the Habitat Conservation Plan, and the HMP. The HMP requires underlying jurisdictions to manage, at a minimum, the habitat management areas. That management process might also require the acquisition of a take permit. The idea here is the funds on hand that FORA has, if there's no HCP and no JPA, that the funds we have on hand would be set into a fund that would be for habitat management and take permits, similar to what the HCP is set up to do. Transportation, finding that we would like to complete, that FORA board would like to complete as the transportation network, that on-base projects would be assigned to the jurisdictions, regional to the Transportation Agency of Monterey County. Extension of the FORA CFD, again, would be the best way to generate revenue for those transportation network projects, and otherwise mechanism would need to be addressed in the transition plan implementation agreement. So if FORA sunsets, you all will recall that the FORA Community Facilities District also sunsets, and it's often seen it referred to as the $72 million question. How do you collect, in particular, how do you collect the revenues on already entitled development? And I know City of Marina has been working and is out in front of this, trying to work with its developers to amend agreements to try to come up with a collection mechanism to address that issue. But to date, we've only seen one written agreement that has provisions, and I reference that in my board report. I do think there's some easy ways to address some of the concerns I have with the language, but the transition plan implementation agreement process is a way for each underlying land use jurisdiction to address how it would like to comply with the transition plan that this board ultimately adopts. Environmental services, another big picture issue. Environmental services contract goes to 2028. It comes with a $6.8 million reimbursement agreement, but it does mean that somebody has to take the obligations for what has to be done, and then is responsible to submit the billing and receive the reimbursement. FORA has very specialized staff in its program that have both the regulatory relationships and the knowledge and institutional knowledge to deal specifically with the environmental services cleanup program. So accordingly, this section expresses the intent that the ESCA program should be extended. FORA should be extended for that part of the program, or the obligations should be assigned either to the Seaside or the County of Monterey. Both have properties and long-term ESCA issues, the bigger issues, and they can decide as between them whether they would like to form a JPA to handle that and take the existing funding and staffing that FORA has and transfer it to a successor. Building removal. Building removal is included in this transition plan resolution, and it talks about if FORA land sales revenues are extended to contribute toward building removal, or if FORA is not extended, the removal obligations would revert to the underlying jurisdictions. And that's a complicated issue that we do expect, given the earlier board action, our financial consultants will help us determine how to address that. But in general, building removal has been expressed by City of Marina and City of Seaside would be beneficial to the entire region, because not only would the property values increase, that means the property tax revenues would increase. There are some good reasons why you might want to accelerate building removal for all and for the entire region, some or all. So we've addressed it in the transition plan. Next slide. We talk about a funding and escrow account. This is where FORA dollars can be transferred into a single escrow account and then shared either through agreements or reimbursement agreements dispersed to access that account. So that would need and should be more fully addressed in a transition plan implementation agreement. Water, wastewater, augmentation, and water transferred to MCWD. I don't think there's any question about that. MCWD is already providing service, but the FORA board does have an interest in ensuring that the entire base is served with the water resources that it received from the Army in a fair and equitable manner, and that there are two ways to fund it. You could either fund water augmentation through revenue sharing, or MCWD has said we can create a capacity charge that will collect all of the money to replace the 17 plus or minus $1 million that the FORA CIP, Capital Improvement Program, currently designates for water augmentation. And finally, this section says that the water allocations in place as of June 30th, 2020 will remain in place unless modified by agreements between the jurisdictions. So this is a little bit of a change from Marina Coast Water District, adjusting water allocations. The water allocations would be adjusted through agreements by the jurisdictions. And another one, policy issues. So there is a provision in the transition plan resolution that the master resolution directs FORA staff to record the master resolution so that all of those policies vis-a-vis prevailing wage, RUDG, and other things are captured and in play for notice to the public who have received deeds that say you must comply with the base reuse plan and the master resolution policies. And at least one court has concluded that because FORA has those policies available and in play, that they are covenants running with the land, lest there be any questions about what those policies are in the future post-FORA, this is our attempt to try to address that so that everybody is on notice of what those policies are that were referenced in the deeds. Section 4 is your CEQA compliance chapter or section, and nothing in the plan commits any one project to being built that's not already in a capital improvement program or evaluated by CEQA or NEPA, and that the transition plan adoption is exempt from CEQA. Section 5 is the LAFCO review and enforcement section, and it requests that LAFCO address with specificity any deficiencies in the transition plan and return it to the FORA board. So the idea there is compliance with the Authority Act. This board adopts the transition plan. It's not modified or changed by LAFCO. It is adopted by the board. So we are currently aware that the LAFCO staff and believes that the only way a transition plan is adequate is if every provision of it is implemented by agreement. And we disagree with that, but at this point, your transition plan resolution is a hybrid. It says this is the plan that we would like to see, and we are going to give a period of time to negotiate those agreements. And at that point, we're going to review it in March of 2019 and figure out how we're going to proceed. If we're going to have to litigate or legislate some way out of the agreement, that some other resolution of this dispute. And your resolution requests that LAFCO enforce the transition plan that is adopted by this board as though they were conditions of dissolution in the absence of fully executed agreements. So if there are fully executed transition plan implementation agreements that meet with this board's approval to implement the transition plan, then you don't have to worry about this. If there are not, though, that begs the question of what happens. And right now the plan is drafted in a way that requires LAFCO to impose its conditions. And if this were a special district dissolution, LAFCO would, under Cortese-Knox, there's a process where they impose conditions of dissolution. They disagree. They have that power, but the FORA Act does say that LAFCO is the one who's supposed to provide for the orderly dissolution. So we think this is consistent with Authority Council's interpretation, and I think the legislative intent when it adopted a transition plan provision in the Authority Act, but this is what's in your resolution as of today. So let's talk about transition plan implementation agreements, because that's a little bit of a new concept, I think, or a newer concept, but it's in response to the request that there be these agreements in play. And I know the County of Monterey has said multiple times that it has been in discussions with City of Marina and City of Seaside to try to get to some agreements on some of the issues on transitioning. So we would anticipate that a transition plan implementation agreement would have a background and some definitions, and then how a jurisdiction will implement the transition plan assignments. For example, revenue generation, revenue sharing, offsets for performance of contractual obligations, or if, let's say, the county is building Davis Road, how that works into the whole equation. A schedule of formation of replacement financing districts or JPAs with other entities, and how any assigned projects would be handled. And finally, how the jurisdiction intends to comply with enforcement of policies for forward developments. So I'm going to give you some hypotheticals. Thought this might be helpful in terms of explaining what it is that we're thinking or trying to get to. And these are hypotheticals. We have not had any conversations with any specific entity on this. Hypothetical only. Example 1, a transition plan implementation agreement with a non-land holding jurisdiction. We would anticipate that that agreement would look like, it would have the background and the recitals, it would have the definitions, and then I'm going to pick on Salinas. Did they leave? Yes. No, maybe bad example because Salinas left, but we're going to pick on Salinas. So as outlined in the transition plan, Salinas will have 7.69% of administrative liabilities and will become a 7.69% successor entity to any administrative liability, for example. And it might also include Salinas shall not have any liability for contribution for any real property related costs, liabilities, obligations. It might also have provisions that lock in place where the administrative liabilities cut off. So it might say we share 7.69%, we will have no liability post June 30th, 2020 for administrative liabilities that might arise after that time. Just an example. The harder implementation agreements, as you have guessed, are the ones dealing with the landholding jurisdictions. So for these, I've called out, and I'm going to pick on the County of Monterey as an example. So you would still have the background, and you would still have the recitals and the definitions. And in terms of dealing with the administrative, it would say something along the lines of outlined in the transition plan, county will have 23.1%, that's the 3 votes, of the administrative liabilities will become a successor in that percentage for any future identified liability. The real property obligations would be addressed in the following manner. Transportation, and again, these are hypotheticals. It would be the intent to deal with the capital improvement program, all of the contracts that deal with reimbursements and other roads, etc. But here's an example. FORA has identified 8 projects are located within the county lands. Projects 1 through 7 are already included in the county's capital improvement program. County will amend its capital improvement program to include any project not already identified in its capital improvement program by June of 2019. It can be it can be a date, but we're looking for a date and a schedule, a target. County will enter into revenue sharing agreements to address contributions by the FORA jurisdictions by June of 2019. This is a hypothetical for how it might be addressed in the transition plan implementation agreement. So that's just transportation, but we have habitat. So habitat, county agrees to address habitat management obligations in the following manner. Intends to form a joint powers agency for the purposes of managing a habitat conservation plan no later than, let's say, June of 2019. Again, it's a date, and June of 2019 is a target date based on the habitat conservation plan is hopefully to be done in April of 2019. But irrespective, if that is not formed, county agrees it will, for example, manage and receive a habitat trust fund to be managed as outlined and approved by the FORA board for the long-term management of habitat areas and take permits necessary to enable development on Fort Ord lands. These are hypotheticals. We have had no conversations with county staff about these provisions. It's just to give an example of how a transition plan implementation agreement provision might work. Policies. County will enforce base reuse plan and master resolution policies. For example, prevailing wage, the regional urban design guidelines, consistency determinations, fair and equitable contributions through, let's say, application of its general plan policies. To date, those policies are specifically identified in Chapter 9 of the general plan for the Fort Ord land use element. To the extent policies are not addressed or consistent with the existing base reuse plan or master plan policies, county will amend its general plan or implement through other identified policy enforcement mechanisms such as conditions of approval. So we're not telling the underlying jurisdiction how to do it. Many of the jurisdictions already adopted policies that implement the FORA policies. This is saying, let's call it out in the transition plan implementation agreements, identify where they are so that everybody can be on the same page from a regional standpoint. So let's talk about some of those key issues. We've talked about a little bit about the LAFCO FORA jurisdictional issue, and I think also the City of Marina has raised similar issues about the nature and extent of what the FORA board can impose through its adoption of a transition plan, what LAFCO can impose or require as part of its obligation under the FORA Act. So again, just reminding everybody that the transition plan shall assign assets and liabilities, designate responsible successor agencies, and provide the schedule. it's approved by the FORA board. LAFCO provides, shall provide, not may, not could, it shall provide for the orderly dissolution. So your transition plan approach asserts that the FORA board exercises its assignment power through the FORA Act legislation and assumes the implementation of the transition plan is done through agreement, but if not through agreement, then it requests that LAFCO ensure that dissolution as though those assignments were conditions of dissolution. Revenue generation, revenue sharing. This is the Community Facilities District issue. It's a big issue and what your approach is. So for this one, I'm going to go through a little background. As many of you are aware, but I will remind everybody and the public that FORA's Community Facilities District is a Mello-Roos special tax district. It is not subject to LAFCO jurisdiction. I think LAFCO and FORA agree on that. It does not require a nexus in terms of how it imposes and collects fees. It allows for the payment of the specified public services and public facilities as outlined in the Community Facilities District language. FORA's CFD is a little different from most community facilities districts and Mello-Roos special taxes in that FORA's CFD is a one-time payment. Most Mello-Roos special districts are annual repeated payments that are put on your property tax bill and you see it over a period of 30 years or something like that. So in that regard, FORA's CFD is somewhat unique. In that it's paid on issuance of building permit, but the people who have already paid the tax are now currently allowed to vote on whether or not you extend the tax. That's a little bit of a nuance in terms of special districts, Mello-Roos special districts. It terminates on FORA's dissolution, and there is no current mechanism to transfer. So your only CFD extension options, and we've outlined this multiple times, is you extend the FORA Act, or you amend Mello-Roos to allow for the transfer and continuation. And it would most likely require both legislation and a vote of the Community Facilities District to extend the end date, to allow the maximum to be collected under the CFD and transfer it to the other underlying entities. So what are we talking about in terms of magnitude? You all have seen this. This is the transition summary. The outstanding transportation obligations, $132.3 million. Water augmentation, $17.1. Habitat management, a big ticket item, $45.1 million. $194.5 million projected as post June 30th, 2020. And the administrative liabilities are projected at 6.6 to 8.8, and I'm putting a star there because CalPERS in particular, that's the CalPERS, just the CalPERS portion of it, it's the biggest ticket part of it, needs to do a actuarial evaluation and calculation upon receiving a notice of intent to terminate the CalPERS contract. And so we do anticipate that and bringing that back to the FORA board in the December or January timeframe. CalPERS has requested 18 months, almost 18 months, to allow them to fully evaluate and prepare that actuarial evaluation. So we won't know an actual number, but we have encumbered in a Section 115 trust a good portion of the range that CalPERS currently projects for terminated agency unfunded liability. And we have additional funds on hand that we think will fulfill all of this amount. So the transition plan approach. This is a big ticket item. These are the target allocations, and they are based on the outstanding development in each jurisdiction. So Marina has the most development amount left and projected. The total for habitat, transportation, and wastewater water is $86 million. Seaside, 42.6. Delray Oaks has quite a large chunk at 32.6. The county has a remaining 19.4 million, UC 12.6, and Monterey has a littler number, and we think that the transportation is zero. Maybe Jonathan can give me some additional input on that. But one of the reasons the numbers are so low for Monterey is currently they are scheduled for industrial development, which is given a huge break in terms of collection of the Community Facilities District fees. And the reason for that is this board made a decision to promote economic land uses. And so not only do they have a smaller land mass, but they also, you can see it here in the break on the overall fees. Next, the transition plan approach assigns a dollar contribution per outstanding capital improvement projects and the outstanding development. It's both entitled development and projected development that's included in that. If we were to only input all of the costs, all of the expenses on entitled development, of course, the cost to the city of Marina and to the county and a little bit to the city of Seaside would be substantially higher because all other development would be speculative in order to finish the entire capital improvement program, if that's what this board determined as it moves forward. The way your plan is currently drafted, it allows each jurisdiction to execute a transition plan implementation agreement on how it intends to meet those obligations. And it might be, for example, that City of Marina includes habitat management in a new community facilities district, and they intend to address transportation by building the underlying roads within your jurisdiction and enforce policies through its application of its general plan policies. For example, that might be how they chose to do that, or it might be they want to revise their development impact fees. We're not going to be saying how to do it, but that you have flexibility to tell this board how a jurisdiction intends to complete what's left. Environmental services, let's talk about that. The environmental services contract has a successorship paragraph or provision, and it requires Monterey County, Seaside Marina, or a JPA to be a single entity successor. We've included Seaside or County of Monterey. Marina has very little, I'm going to call it skin in the game, maybe the wrong terminology, but in terms of future ESCA obligations, and a JPA. So there's some flexibility there for the county and the Seaside to have conversations about whether one or the other of them wants to take the obligations or if they want to form a joint powers agency to complete the program. That would be addressed in the implementation agreements. And if the JPA is formed, then they would be assigned the contract under ESCA, and we would ask the Army to do what it needs to do to make those assignments. Wouldn't be complete without making an observation and talking about legislative amendments, because I think we've outlined some issues that need potential legislative clarification. One is in section 67700, and that is both the end date and for what purpose. And I'm going to give you some examples. Again, these are hypothetical examples, but for example, you might adopt a transition plan but ask for legislative extension for transition plan implementation for a period of up to 10 years, or until the transition plan has been implemented, for example, or until all the entitled development revenues have been collected or replacements have been put in play. Or you might just change the end date, clarify the FORA board's power to determine and assign liabilities, clarify LAFCO's enforcement powers. There are lots of possibilities, but the end date and for what purpose. Heard lots of conversation about board membership. FORA Light, sometimes I've heard that. It means different things to different people. To some people, it means changing the board membership to just the underlying land use jurisdictions. We've heard that. We've heard change the composition to underlying land use jurisdictions and add California State University because they have a large piece of property, make them subject to FORA board authority and this assignment and transition plan. Reduce total number of members and include it as a weighted vote. It's currently a weighted vote now, but instead of having the number of members we have today, you would have one person from the County of Monterey, for example, instead of 3, and that one person would exercise 3/13 of its vote on the board. Section 67688888. That's right, the conduct of business. This is the unanimous vote clarification. All action by majority vote instead of by 2 votes or unanimous first vote. The 2-vote rule, I call this sometimes the 2-vote rule. It's a little bit of a misnomer, but it is how it has been interpreted for the entire life of FORA, basically, is that if it's not unanimous the first time around, it requires a majority vote the second time around. Section 67684, which is policy enforcement. Nature and extent of FORA policy enforcement. And here we're talking about prevailing wage, affordable housing, jobs housing balance, consistency determinations, things like that. And consistency determinations are not, by the way, found in section 67684, but the idea here is that clarify the FORA Act vis-a-vis policy enforcement. Do we still need FORA to enforce policies? Do we want to increase or change how policies are enforced? We've heard that as potential legislation here. So let's talk about a little risk comparison, because I know that there's a chart that got handed out on your dais on the left-hand column, the revenues column. And this tries to get at kind of the difference or the risk of what your transition plan currently says and what potential extension would mean in terms of evaluating the revenues that come in to pay and to reduce the obligations that face this region. And so on the left-hand side, revenues, currently your CFD on entitled development is projected to collect $72.72 million. Your proposed development under the Community Facilities District is proposed to collect $55.2 million, and your land sales property tax collects about $67 million. That is how our capital improvement program is built. And I would note that the property tax line, that $67 million, while FORA is in play, has special legislation. About $30 million of that is from property tax revenue collection for FORA. FORA, it has a different formula than if the property taxes revert back to the underlying jurisdictions. Yes, underlying jurisdictions will get, upon FORA dissolution, some increase in property taxes, but I don't think it equals the exact percentage that FORA is able to collect and put toward the finishing the program. So under the transition plan, it changes a lot. You have the jurisdictions are going to have to figure out how to replace the entitled revenue. And that's a big ticket item. Again, Marina has already gotten out in front of this a little bit and executed at least one agreement that has a process for collecting on an already entitled development post FORA, a replacement mechanism. So that would be, you know, there's some other language in there that qualify how they will share revenues, which I'm not sure will meet with or meets or completely addresses the transition plan as it's currently structured, but I think that's a fairly minor issue in terms of clarification. The proposed CFD, we anticipate the jurisdictions would have to address that too. But for those proposed developments, as I was outlining earlier, if you're in a jurisdiction that doesn't have an entitled development, it's easier to form a new district to exactly replace what FORA would generate under its Community Facilities District. And land sales property tax. Jurisdictions are also going to have to figure that one out as well. That is, there are implementation agreements that I understand are disputed about whether or not they continue on beyond FORA or not. But in general, the jurisdictions are going to have to figure out how you make up the shortfall. If you extend, FORA collects and distributes all the revenues it collects on entitled development. Jurisdictions still need to decide on how to replace the proposed CFD. That's actually part of the transition plan that we're encouraging the jurisdictions that don't have entitled development to get going on forming those replacement districts. We would hope that an extension would be implementing this plan and that those would be put in play and ready to spring into existence at the appropriate time. And FORA would be collecting the property taxes and any land sales revenues able to be directed toward retiring the program. So it's just an attempt to try to get to the risk comparison of your options on the table. We've requested that transition plan questions and comments be sent to planning@fora.org. To date, we have not received any emails on this website or email address. We've received lots of comments in the weekly and some letters separately, but nothing through this methodology. And I'm just reiterating this is available for use. So what's your overall timeline? I'm getting close, but I'm glad I'm sitting down. Overall timeline is the board approves the transition plan. It has to be sent to LAFCO by December of 2018. October, and we are anticipating that would be done in October. October 2018 to March 2019 would be transition plan implementation agreement, negotiation, and execution period. The more transition plan implementation agreements that can be executed and submitted to LAFCO in December of 2018, the more complete your plan is. Not that your plan as it's currently drafted is incomplete. I don't think it is. But given the LAFCO comment and the desire to have everything implemented by agreements, the more agreements, the better. December 2018, we would submit the transition plan and any agreements to LAFCO. And in March of 2019, we would be coming back and evaluating what the next steps are to resolve any ongoing issues, jurisdictional issues, transition plan implementation agreement status. And in March, we would need to make a call. I think this board has to decide how it would like to proceed in terms of implementing the transition plan. If it intends to clarify some of the jurisdictional issues by litigation, clarify what it means if there are not agreements, or by legislation. And that concludes my presentation.
Thank you, Ms. Damon, for that presentation. It provides a lot of questions and a lot of information. Let me start off by saying I don't think that we're going to have any motions today, to really not think about that. So any kind of direction we can get staff for next steps would be greatly appreciated. I know that we need to get something over to LAFCO by December, and that may just be the transition plan, and then take the next steps with the implementation agreements. I think that maybe staff could get started on those implementation agreements with the administrative committee in terms of some boilerplate language by category, where we can stick in the jurisdiction and what the percentages and what the agreement terms are. But we need to have a starting place for our city managers and CEOs to start this discussion. Michael, you had something to add?
Well, I'd agree. Given letters we received from the County of Monterey earlier this week, the letter and transmittal we received from the City of Marina Wednesday and yesterday and today, the ongoing council deliberations on this issue at Monterey next week, as I recall, would lead me to suggest that what we could use as staff was some general direction on how you want to proceed with this resolution, which we believe encompasses all the things that the legislation asked us to do, maybe it doesn't say precisely what everybody wants it to say, but it does do what the legislation requires us to accomplish. But I think it would be a good idea for the board to consider scheduling an action sometime in October, not necessarily at the board meeting, because as again, you only have 45 minutes more today, and I think we'll probably lose some board members before that. It seems to make sense to schedule the time, not when it's a board meeting where this can be the focus and we can go through the individual items along with the comprehensive nature of a resolution that sets forth a program for moving ahead. We at staff still think that's the best approach. There are some real serious questions to address, and the county's letters lists a series of legal questions. Our colleagues at LAFCO have one opinion, our colleagues at the county have a different one, and there's all of those questions that Sherry pointed out are not simple ones. So my thought would be give us some direction on how you want us to proceed. Maybe take comment from members of the community who came here today just to talk about transition. I know there's representatives from Marina and other places that came just to be able to make a comment, and then set a schedule for maybe a meeting in October where this could be in a deliberative process discussed.
Yes, questions? Go ahead.
Was that, okay, thank you. So, Sherry, when you're looking at the graph, you were, I think on your picture, page 20 in today's presentation, actually 37. And the City of Marina did pass out a bar graph, which was, and it's sourced from the FORA presentation at the June 2018 presentation on the Transition Task Force. It is not changed. It is the exact same bar graph. So, because you made a reference that we passed that out, it's the same. On the left?
On the left, I believe it is the same.
Yeah, but this is your source, and it's dated 5/23/2018. It was part of your presentation.
No.
So I just wanted to make sure everybody understood this is a FORA document.
Yeah.
Okay. So one of the findings that you set forth is that the funding mechanism, you're asking the board to make a finding that the FORA CFD is the funding mechanism that will work. And question that I have for you is, on this bar graph, you have 194.5 million as the FORA's share for transportation, habitat management, and water augmentation. And in fact, those roads that are falling in jurisdictions that are only getting reimbursements, there will be additional costs, correct?
I believe that to be the case, that, like, for example, Davis Road, the FORA CIP contribution is about $12 million, but I believe the road in the county's capital improvement budget is about $60 million, plus or minus. And I could be off a little bit, but yes, if that's...
So from the standpoint of the City of Marina, the FORA CIP, and I'm sure other jurisdictions whose roads are within the territory, is that we're getting a reimbursement. So City of Marina has multiple roads. We have 8th Street, we have 2nd Avenue, the extension Del Monte to 2nd Avenue. We have multiple roads that we need to put in as part of this traffic circulation and what's in the CIP. And we get a total of $12 million reimbursement, and FORA's paid us a portion. But the roads are going to cost more than that. So for those of us that are land use jurisdictions with our land within the former Fort Ord, how do we fund the additional costs over this $194.5 million in your model?
Well, this model doesn't deal with how City of Marina deals with its share of its roads. So this only deals with FORA's contribution toward the roads that it is going to be put forward. So, for example, Del Monte Extension. Let's say that that is a $13 million project in your capital improvement program. FORA's capital improvement program says FORA will contribute $2 million, let's say, toward Second Avenue, and I think that might be close, maybe $4 million. It's some number. We contribute some proportion. This expense model and the FORA CFD deal with only the FORA contribution. But if I were going to give you suggestion about how you capture this, my thought would be that you form a community facilities district to deal specifically with shortfalls for purposes of roads and other things. It would be a tax. That would be one suggestion for you, how you would make up the FORA portion.
So under Government Code Section 67679 D, this is what the City of Marina was addressing, is that we're precluded, every jurisdiction, Seaside, Delray Oaks, every jurisdiction whose lands are within the territory of former Fort Ord, we are precluded from imposing a tax, a Mello-Roos, there's 12 different mechanisms, that those are deprived of us if the Authority Act continues or if FORA continues.
Actually, that is not, I don't believe, a fair interpretation of that section, and under the implementation agreements, each jurisdiction is allowed with this board approval to establish land-based financing districts to replace the FORA CFD. So it is possible for you to move forward with that, but if your contention is that the Authority Act is somehow unclear, that is something that should be clarified, because currently that is how FORA interprets it, is that you are able to form a Mello-Roos district with this board approval.
That is, I agree with that interpretation, with the board approval. But the question becomes, FORA's reduced its CFD from $44,000 per residence over its existence to $24,000 to get development to go forward. So for the City of Marina, we're happy to say there's a shortfall, that we need to add $10 million per house. How is that going to impact the build-out of former Fort Ord? Do you see that as cost prohibitive to developers, or the development we all want?
I'm not sure that that's 100% within my scope of ability to answer in terms of whether it's cost prohibitive or not. I think that currently all the developers are paying both Marina's development impact fee and FORA's impact fee, and so if you're just replacing one tax with the same additional tax, the impact to a developer should be exactly the same.
Yes, but if we're adding it to make up this shortfall, it's going to be a higher
You're not
number.
adding it, though, I don't think, to making up the shortfall. You're just replacing it.
Okay, so I'll move to another question. You used the City of Salinas, and you said City of Salinas is going to be responsible for one voting share of the CalPERS obligation, and additionally, in the June 8th presentation, included in the administrative costs were potential settlement agreements and court judgments. Would the City of Salinas be taking a percentage share of those liabilities as well as part of their administrative cost assumptions?
As your transition plan is currently drafted today, but it could be changed by a majority board vote, yes, the settlement agreement and indemnification provisions are included in the administrative liabilities. But in thinking about it, really, the settlement agreements which affect only the landholding jurisdictions, I would probably interpret as a real property related expense to be borne by the underlying land use jurisdictions and not the non-landholding jurisdictions. And that's what I would expect Salinas to come back and say, as I would expect any of the non-landholding jurisdictions to say.
So if there's a legislative act by this board that results in a judgment, what you're saying is that would be related to the land only, or would that be related to an administrative allocated administratively?
I think what I'm saying is you would look at the judgment or the settlement and make a determination as to what that judgment or settlement is directed towards. So in the example of, let's say, the Sierra Club settlement, that affects real property obligations, how you build out, that would be a real property obligation. Salinas wouldn't have liability for that. If you were looking at a CalPERS shortfall, that is an administrative liability, and we would be looking at that. That's not a settlement or a judgment. Let's say there was a slip and fall. That's a bad example. I'm trying to think of a
Well, let me use an example, because this is the one that I'm worried about.
Okay.
Is that previously there was a stipulated agreement that the county and FORA were going to pay $5.5 million in attorney's fees. $550,000 in attorney's fees. 275. It wasn't millions, thank goodness. But would that be characterized as, it was because there was a CEQA violation, would that be characterized as administrative, or would that be characterized as real property?
Well, I guess I have two things to say about that. First of all, that judgment has been satisfied.
I'm just using it as an example.
I understand, but essentially, but just to clarify for the public, lest anybody in the public think that anybody owes any amount of money in attorney's fees for a CEQA violation, we do not. But if there were a settlement agreement affecting that particular issue, that would most likely, I would consider that a real property obligation. It affects a evaluation of a real a road improvement that affects the overall reuse of the base. So that would be property based, not administrative.
Ms. Morton, I'm sure you have more questions. I'd like to hear from some other members.
Go right ahead.
Ms. Garfield.
Thank you. And I just, this is a timely interjection, is that I could argue it the other way too. So I think it demonstrates, and I'm sitting here going, but it is of great interest that we figure out the administrative. And my concern was, in here you've said, in a couple places, I believe the way I'm reading it is that there may be things that occur that we don't know yet later. And so for all of us, when's the cutoff date? When do we say, well, this is what we're signing off for, and the implementation agreement we are willing to sign has this wall around it? And then subsequently, what, if anything, could breach that wall to change the amount that we believe we're going to be responsible for? So that's one thing I think needs to be settled. And maybe other people understand that better than I do, but I don't understand it. The biggest one is you have lots of language in here that says shall and will and gonna. And to me, it seems like trying to push rope uphill. How do you compel Pacific Grove to sign an implementation agreement that we don't want to sign? And I think that applies to all of us. And even further, and I'm going to use the habitat, is that because it's the one I think we all agree is just the most wonderful thing we all need to do. How do you get, if I may, the city of Monterey to sign on to a collaborative, and they don't want to do it? But it's important for the collaborative and for all of us that they do so. I mean, how big a stick do you have? And I don't know that we've determined that either FORA or LAFCO has the ability to compel any of these desirable actions. And that, I think, needs to be settled before any of this can even be agreed upon.
Okay, Mayor Edelin and then Supervisor Phillips.
Just real quickly, sure, that's an outstanding presentation, a very difficult one considering our collective makeup of the board and so forth. Just something it finally occurred to me, correct me if I'm wrong, we're looking at a proposed community facilities district coming in for roughly for the proposed $55 million. That's based on the base reuse plan approved projects that we have in there right now, and your jurisdictions are not allowed to exceed the density or the intensity of the land use of above that. That will generate the 55.2. With that 55.2, we're still looking at up to maybe between a $20 and $40 million shortfall in habitat conservation. If the jurisdictions decide they don't want to be that intense, they want to have more park land, or they don't want to develop whatsoever, or they're stopped from developing whatsoever, that 55.2 disappears, right? Yes.
No.
No.
No, it does not. The 55.2 right now is on entitled development. So the only way that changes, I think, is if...
No, that's proposed.
Oh, I'm sorry, I guess I
Proposed.
got it wrong. Yes, proposed, yes, that could change based on underlying land use and what is actually entitled.
So basically, we could end up with zero. If the absolute worst case, you'd have absolutely no
you
money
could.
whatsoever for habitat conservation for any of the proposed CFP.
In theory, yes, that is true.
Okay, so now
Also-
you have the last question, and I'll shut up, and that is there any way, right now we have the FORA land separate from the rest of the jurisdictions. Is there any way, if we have no money for habitat, then anybody can come after the jurisdiction and say, well, you're going to pull money out of your general fund to fund habitat, even though it has nothing to do with the FORA Act itself? Are our general funds protected from future attack?
I'll answer that one, because if you've accepted property, it typically has a requirement that you comply with the base reuse plan, with the Fort Ord Multi-Species Habitat Management Plan, which does have a cost. That is an obligation. It may not be an obligation of your general fund, but it is a city obligation. So whether that's as a part of a future project, or if you have a developer to pick that up for you, that is an obligation. That's what you signed on when you took the land.
Supervisor?
I really just wanted to talk about procedure a little bit. I know at our board meeting, we really felt that we had a lot of concerns. Wendy Stremlin's here from the county council and is looking at that and is going to prepare a response and looking at it. And so I think today we're not, like you said, not ready to do something. We're going to have to do something sooner than later. I think you're right. Some kind of special meeting's going to be necessary. And we got to get to the question. I think we kind of all agreed this requires just one vote, not dual votes. But I think we agree on that, but that's not definitive. But I got to say, at our board meeting, we voted on a 3-2 vote, but we voted that we think we need to explore some legislation to extend FORA in some fashion, because frankly, I look at what Marina's filed and the concerns that the county has, and on this board, unlike the other boards I'm on where we usually agree on everything, this board, I have a real question whether we can reach the agreements that are asked for and demanded by LAFCO, at least at this point in time, and without some legislative overreaching in some form, whether it's big or small. And so that's one of the things I think we have to explore a dual role, because I have a real concern on a complicated issues like this, from looking at it strictly from the county standpoint. We got to protect ourselves in how we're doing it, and reach an agreement is just real difficult to do.
Mr. Alpert.
Yeah, it seems to me that there are certain agreements that we could get to quicker than others, and we should have staff immediately work on them, like with Marina Coast Water District, maybe with TAMC, and maybe the ESCA with county or seaside. At least we need to know which of them is willing to do that. And I would say staff need to get working with those groups to get implementation agreements on those as quickly as possible.
Okay, Ms. Parker. And then
Thank you. Yeah, in the line of suggestions, I think one thing, just thinking about the transition plan, LAFCO has said that this isn't a transition plan, that they need more detail, and I think agreements between the jurisdictions is a way to start to deal with that, but I I don't know that we're going to have them sufficiently in place to incorporate them into any sort of transition plan that we submit to LAFCO. So another alternative might be to explore with LAFCO whether they would accept kind of benchmark actions and agreements that we're planning to get, by which time, who's responsible, that kind of stuff. It provides more detail, and while we're also working on agreements between the jurisdictions, I also think it makes sense to hire a facilitator, someone with some legal negotiation skill, to start working with the jurisdictions, because a lot of the agreements are not necessarily between FORA and the jurisdictions, but rather between the jurisdictions. And so for FORA staff to get involved in it, it actually may confuse the issue from the perspective of the jurisdictions coming to the kind of agreements they need to come to. So that's just a suggestion that it might be really worth our while to spend a little money to have some folks really working quickly, tightly, thoroughly with the jurisdictions to come up with some agreements, and to have as many in place by December as we possibly can. I don't know that all of them will be, but I agree. I mean, there are some of these where the path is clearer, and I think we can get some agreement. I did just want to say that county staff had some concerns about the way it was characterized that meetings had occurred between the county and the cities of Marina and Seaside. There was one meeting with Marina to talk about the fee idea, how that was the CFD and a replacement, and there was one conversation with Seaside about the ESCA issue. The way it was said, it sounded as though there had been multiple meetings. That's not the case. There was one each, and they were informal and just informational. So I wanted to just point that out. I also want to say that in the staff report, the characterization of the Fort Ord Committee's position on the Habitat JPA was also inaccurate, at least according to my recollection of what we said. It said that the county Fort Ord Committee was going to take a wait-and-see approach. What we spelled out was that our preference was to have an HCP JPA, and if that was not in place by a certain date, that we would fall back to a JPA for the habitat management plan. That's not wait and see. That's pretty clear. So those are my suggestions at the moment.
Okay, Mr. Moore.
So I'm still a little bit unclear about these transition plan implementation agreements. Could you give me a rough idea of, number one, how many there would be that you envision, and who would you envision to be the actual signatories to each?
Yes, I think all of each jurisdiction, so the basic landholding and non-landholding jurisdictions, Marina Coast Water District, the Transportation Agency of Monterey, California State University, UC, everybody who has a skin in the FORA transition game, and all of those entities do. So I would anticipate that agreements would be there. So at least each of those folks would be the signatories, and whether it would be FORA and LAFCO, or someone else, my anticipation would be FORA at this stage of the game, with an assignment provision for successorship.
So these would essentially be a whole series of bilateral agreements.
They could, or they could also be designated to have other entities be successor, third-party beneficiaries to those agreements.
So just to,
Adams.
thank you. So a question that I have actually for Mr. Hulamard is, do we need to have a motion to move forward with finding a consultant that can come and help us work out the kinds of contractual sorts of things that we want to do so that we can get the plan ready to send to LAFCO, or can we just go ahead and do that, just, have that happen on our own?
We couldn't take an action on that.
Because it was not recognized in the agenda. But so do we need to do that, though? So, or can we simply go ahead and provide direction to the executive officer to do this?
What was on your transition plan process update today for information and action included number 5, which is provide direction to staff on policy or other revisions to the transportation or consider adoption. So I think that that's fairly broad. Provide direction on likely successors, provide direction on multiple things. So I think you could give direction that says, please seek this professional negotiator, facilitator. I'm not sure what the language was exactly. You called it consultant.
Words work. Yes, I used consultant just in a broad sense, but I think we understand what we're talking about.
Yeah.
Someone who would be outside the realm with no vested interest, who would be able to guide us in the work that we need to do to have a transition plan ready for LAFCO, which would incorporate what Supervisor Parker had said, which was essentially the tasks, the timeline, and the who's responsible for. Because we don't have to have agreements within the jurisdictions as we present the plan. It's just a layout of here's what we need to do. That's a plan. It's not, we have until 2020 to complete the agreements, but we simply have to get it laid out exactly what it is that we need to accomplish. That's a plan.
So there are multiple different things that I've heard, which includes potential agreements that would be between Fort Ord Reuse Authority and, say, a non-land use holding jurisdiction about what their administrative responsibilities are. That's one kind of transition planning implementation agreement, that there would be some negotiation, facilitation, someone to assist us. There are others that might be agreements between City of Marina and the County of Monterey. You get us in the middle or our consultant, I think that's getting in the way.
Totally, I agree. And in addition to that, we don't have to have the agreements in place. We simply have to tell FORA this is what our plan is. We don't have to say, yeah, let's just shake on this. That's not necessary for a plan. So I would just hope that we can move forward with this, though.
Mr. Monterazzo, and then
Thank you,
Ms.
Chair.
Garfield.
I hope when this comes back, it's more recognized what a capital improvement program is. We have some public works people here, and those costs are not set in stone. They change all the time based on different land use scenarios, and as Director Edelin stated, those land use scenarios change over time. There may be more open space which doesn't require a road, or the City of Marina decides they can live with going on Highway 1 for a while and don't need the extension of 2nd Avenue. So to assign costs, I think, is the wrong language. I would recommend you say assign responsibilities. And if you want to have percentages of those are still estimated percentages. You can have the estimated percentages of those roadway responsibilities with additional language that actually states the funding options for those liabilities, including grants, future CFDs, traffic impact fees, membership to TAMC, etc. But this is, the strongest point of the plan I've seen so far has said, you will pay these costs. And I don't think that's correct.
Ms. Garfield? Ms. Garfield?
I was distracted by some really good comments. It's a really good way to get distracted.
If I could, what we are not proposing is that these are specific costs that adjust up and down. These are revenues. And so understand that. The responsibilities and obligations are the individual projects which TAMC has assigned us, or MST, and they come directly out of the base reuse plan and its environmental documents. The network on Fort Ord is fairly clearly described, but I think I agree with you. I disagree that these are costs related to projects that are up and down.
No,
these are a fair share.
It says assign costs. I'll show you the section.
No.
It says assign costs.
Then we need to correct the word cost to say revenues.
Yeah.
I think I had it and I wanted to add on to what Supervisor Adams was talking about in sort of the consultative services we need. And I think we need content consultation on how things can be structured. I don't think we're going to benefit that much from a facilitative point of view where somebody's helping us run a meeting better. It's really got to be content expertise on how that party and that party need to structure their agreements and how that's going to work. So I would just wanted to add in on that. Thank you.
And I think we need to involve the administrative committee in that that little discussion because they're going to be the ones structuring the agreements more closely. I'm going to go ahead and open up to the public. We're running out of time, and I do want to hear from the public. I'm sorry?
I'll be real quick.
Sure, go ahead.
I just want to reiterate that I personally feel that the majority vote that the Monterey County Supervisors took was the direction that I would support us to go in looking at keeping some sort of light FORA, if that's a term, and looking at the transition plan at the same time. I just would like to reinforce that concept. I think it's an excellent direction to be going at this point.
Thank you. Let's go ahead and take public comment this time.
I'm not that tall, so you can't see me. Good afternoon. It'll be great to have a transition plan. My name is Margaret Ann Copperno, a Marina resident. I am here to support the City of Marina's resolution. We respect and admire all of you and recognize the outstanding job Mr. Hulmar and his staff have done. You all are the best. You're great neighbors and partners. The City of Marina, I believe, has also been a supportive, cooperative, and collaborative neighbor and partner in resolving regional issues since the closing of now historic Fort Ord. Marina's citizens have invested approximately $85 million in this undertaking for more than a quarter of a century. Now it is time for the City of Marina to fly on its own so it can invest its dollars in urgent local projects that await resolution. Projects that a continuing version of FORA will not take on. Marina has had to endure in its borders projects that other cities did not want and do not want. Those include the sewer treatment plant, the landfill dump, the sole existing sand mining operation that has eroded beaches all the way to Monterey and beyond, violating Marina's local coastal plan, and has devastated the habitat of the snowy plover and other creatures that live in the sand dunes, and more recently the Monterey Peninsula Water Supply Project, whose testlet well is causing seawater intrusion into the Salinas Valley groundwater aquifers that supply potable water to Marina citizens and has contributed to beach erosion, habitat destruction, and much angst as well. The plan is to export aquifer water to other peninsula cities at the expense of Marina, as no plan exists to compensate Marina or to resupply the lost aquifer water to Marina, which is being taken without water rights from an already declared critically overdrafted groundwater basin. What will happen to Marina and the Ord community's sole water supply source? Will it go the way of the Carmel River and the Seaside Basin? The U.S. Army bequeathed the Fort Ord water infrastructure to Marina Coast Water District because it had total confidence in Marina Coast Water District's trustworthiness and water management skills. The U.S. Army was correct. Compare Marina Coast water rates to its counterpart on the Monterey Peninsula. Being a good neighbor, Marina citizens have supported the disruption caused by the installation of many large pipes under city streets to supply recycled water to peninsula cities, called the RUWAP project. I know it well since the pipes were installed on my street. One would be hard-pressed to find a better neighborly example than that of Marina. Marina citizens want their jurisdiction to be under their purview so they can make the decisions that affect their lives, our lives. We already suffered the loss of revenue due to...
Thank you. Time's up.
I didn't talk fast enough.
So I just want to elaborate a little bit further on what Supervisor Parker was talking about with consultation. She wasn't speaking about a mere facilitation kind of function, but somebody who has experience, expertise, a lawyer who understands government structures, financing, all of the intricacies that need to be discussed at the table, someone who can help facilitate that dialogue with the jurisdiction. I don't think, as a staff person sitting here, I've seen this presentation so many times, it's very hard to sit on my hands and hear it 4, 5, 6 times, when what really needs to happen is the conversation that goes beyond this. There's a framing of the issues that has frustrated progress. terminology that has frustrated progress. A declaration of obligations that is so sweeping, it's frustrating progress. There needs to be some give on the part of FORA staff on what they determine to be obligations. Otherwise, progress is never going to be made. Thank you.
I had longer prepared comments, but knowing how late it is, I'm throwing away the whole thing. But I do want to mention a couple points. And at Marinas, we've held multiple meetings, and most recently we held a special council meeting on September 11th and then on September 25th. And on these meetings, I want to make it aware that Councilmember Morton was given an ovation not only by the council, but all the citizens there. And it was a recognition for all of her myriads of hours that she has put in. I mean, literally hundreds of hours. She's probably the only one that has read through all these base documents, and it was really a recognition of everything that she does. And as she speaks not only and works with me as the city manager, but talks on this board and to our council, she speaks from a position of fact and knowledge that she's actually read through these documents. And so I want to make it aware that not too often that happens, but we appreciate Councilmember Morton and Councilmember O'Connell. He didn't get the ovation, but we appreciate him on the board too.
That's okay, Frank. You're awesome anyways.
So going away from my remarks, our council with our 19-page response to it, we've actually, I think, are kind of aligned with some of the LAFCO and the county's concerns that they have, and so we've detailed those 19 pages out. With that said, I think there's been a lot of great comment here that I've heard from the board and some of the direction that you're going. As I've talked with my fellow city managers and Lou Bowman with the county, we are exploring ideas and options and would love to be able to work behind the scenes within the Brown Act and come up with some solutions. We think the timeline can be met. Our goal is to continue the vision of the base reuse plan. It's a great vision. We think it can be achieved. We think it can best be achieved with FORA sunsetting as planned and all of us picking up the base reuse plan. It's already within our general plans. They're already ruled to be consistent, and we think we can move forward with that. And so we're committed to work with the board on achieving that. Thank you.
Thank you.
Hello, Chair, members of the board, Brian McMahon, City of Marina staff. Before you is a chart prepared by FORA staff that you are probably familiar with and has been shared at multiple meetings. The chart shows remaining funding obligations of $194.5 million. It's been stated that if FORA is extended to 2028, there will be a corresponding $194.5 million in revenue generated to cover those obligations. This just isn't true. At the top of the revenue column is land sales and property tax. New land sales and property taxes are projected to be $67 million. Currently, FORA is receiving $2.9 million in property tax revenue, and under current policy will be allocating $1.6 million annually for funding obligations. Take the $1.6 million times 8 years and you get $12.8 million. Factor in property tax growth and maybe you're at $15 million. That leaves $52 million to be received by FORA from land sale revenues. Since FORA receives only 50% of the land sale revenues, that means the land will need to be sold at a value of $104 million between 2020 and 2028. I don't know how much in land sales revenues FORA has received to date, but I do know that from Marina, FORA received $3 million from the Dunes development, and I believe around $4 million from the Marina Heights development, now called Sea Haven. That is $7 million total for the first 20 plus years of FORA existence. The remaining Dunes land sales, if Marina Community Partners purchases Phase 2 and Phase 3, is already obligated by FORA to reimburse them for blight removal. The only remaining large property for land sale in Marina is Cypress Knolls. I'm not aware of any offer on that property for over $5 million, and as I talked with developers today because of the huge blight removal costs, I'm not sure that the property is any more than just a wash. The $104 million land sales number will never be realized. As to the CFDs, it's estimated that FORA will receive $72.2 million in CFD revenue from entitled projects before 2028. That means approximately 2,900 residential building permits will need to be issued in the next 8 years, at an average of 362 per year. For Marina, which will be the largest CFD contributor, we've issued approximately 450 residential permits since the creation of FORA. Then FORA projects another $55 million for projects that aren't even titled before 2028. So what do? Extend FORA and the current funding model and a plan that will not even come close to hitting the target of $194.5 million, which will mean these projects won't get completed, and particularly important to Marina, the blight stays. Thank you.
Thank you.
Good afternoon, FORA Board. My name is Robert Rathie, and I'm an attorney at Rob Wellington's firm, city attorneys for Marina. And I just wanted to mention in the staff report, it's mentioned that there was a Public Records Act request received for our amendments to our development agreements with some of our developers. Well, the normal practice when any Public Records Act request is received, and we know you all take them as seriously as we do, that they come to our office for review and for information as far as disclosability. We've never received that request, so we don't know where that reference was generated from. So I just wanted to make that on the record. So thank you very much.
Any other public comment?
Good afternoon. My name is Eric Peterson, and I'm not from Marina. I'm from Salinas on the other side of the lettuce curtain. And I'm not sure I quite understood the reference to Salinas and CalPERS. The message I got was that there may be a CalPERS liability waiting for Salinas to find out about. Salinas has already got a huge CalPERS problem, and our city council is kind of thinking about beginning to think about maybe dealing with it. And adding to that problem would just be enormous. Another point is, I may be the only one who thinks this way, but I really like the unanimous vote thing. And the reason is, on controversial issues, it's just like a second reading of legislation in whatever body it is. It just gives, for controversial things, it just gives more time to think about it and consider maybe there's a better way. Thank you.
Thank you. Any other public comment? Okay, so now bring it back to the board. Any additional comments, or if there's any questions that weren't asked, please forward them to staff. And I would say that let's look at the resolution while we have some time off to really look at it and come up with some constructive ideas to improve it. I know it's easy to tear a document apart, but let's look at it and constructively criticize it so that we can make a better document and get it into LAFCO on time. The implementation side we'll continue working on, but I think it's important that we hone in on that resolution. Ms. Garvin.
Yeah, it sounds like coming up with, we've talked about having a special meeting to talk about this, is that we really need to get on that, and I really hoped we would get to it before everybody left, but I'd like to see a doodle poll or something coming out tomorrow or Monday.
Saturday?
Yeah.
Okay.
I mean,
we can do that.
This is really imperative, and we've got a meeting in 2 weeks, and we got to get this stuff going. So we need to maybe do a couple of frame outs of when we've got time available, so that we're not trying to dedicate entire days to this, because it's really hard to keep thinking about this for more than maybe 20 minutes at a time, but I think we could stretch that to 2 hours.
Okay.
I agree. Now we've reached our limit on the meeting before we can open any new items, but I will open up for general public comment for things not on the agenda. Seeing none, unless there's a motion to extend, we're adjourned.
I just want to be really, as staff, want to be really clear. The general direction is to set a special meeting. There are a number of items that came up today that you would like to see on that special agenda with respect to transition, including an active interaction with as many board members as possible on improving this resolution before it comes back. Okay.
Yeah, I think that's great.
Doodle poll out tomorrow.
Thank you.
Thank you all.